Hello, welcome to Vidu Law Niti. Today's topic is about Article 12 State. The part 3 of our Indian Constitution deals with fundamental rights. Now let us know what is fundamental rights. Fundamental rights are those basic rights without which a human life becomes meaningless. By fundamental rights, we mean those rights which form the essential conditions of good life and which constitute the essential of human process. In the absence of these rights, the growth and the development of human personalities is impossible. Hence, fundamental rights are very much required for all over development of human personalities. Fundamental rights is a character of rights contained in the Constitution of India. It guarantees civil liabilities such as all Indians can lead their life in peace and harmony as a citizen of India. This includes individual rights common to most liberal democracies such as equality before law, freedom of speech and expression, freedom of association and peaceful assembly, freedom of practice religion, and the right to constitutional remedies for the protection of civil rights by means of writs such as habeas corpus. Violation of these rights result in punishments as prescribed in the IPC, that is Indian Penal Code, subject to discretion of the judiciary. The fundamental rights are defined as a basic human freedoms which every Indian citizen has a right to enjoy for a proper and harmonious development of personalities. Those rights universally apply to all citizens irrespective of race, place of development or a birth, religion, caste, creed, color or a gender. The definition of Article 12. Article 12 refers to a state. The word state will be coming in various articles with the statement referring that state shall have a duty, state shall have a empowerment, the state shall power to do that, etc. To understand the word state, we need to learn the what is the meaning of the state, that is in Article 12. The definition of Article 12 of the Constitution defines the term state. The term state specifies the authorities and the instrumentalities functioning within or without the territory of India, which shall be deemed to be a state for the purpose of the Part 3 of the Constitution. The definition of the state is inclusive and not exclusive. Therefore, authorities and instrumentalities not specified in it may also fall within if they otherwise satisfy the characteristics of the state as defined in this article. The importance of Article 12 lies in the fact that it clarifies the scope and extent of the term state, which is used in many fundamental rights provisions such as Article 14, 15, and 21. These provisions guarantees equality before the law, prohibit discrimination over various grounds, and provide for the protection of life and personal liberty. The authorities and instrumentalities specified in Article 12 they are the Government and Parliament of India, the Government and the legislature of each state, all local authorities, other authorities within the territory of India. Let us learn in detail. The Government and the Parliament of India. This include the executive, legislative and judicial branches of the Indian government at the national level. It encompasses the President of India, the Vice President, the Prime Minister, the Council of Ministers and the member of the parliaments, MPs in both Lok Sabha and Rajya Sabha. The government and the legislature of each state. This refers the executive, legislative and judicial branches of the state governments in India. Each state has its own government which includes the Chief Minister, the Council of Ministers, and the members of the Legislature Assembly (MLAs) and members of the Legislature Councils (MLCs) if the state has one. The next is a local authority. Let us know first the meaning of the what is authority. Authority means a person or a body exercising the power to command. In Article 12, the word authority means the power to make laws which have the force of law. It also includes the power to enforce those laws. As per Section 3 of 31 of the General Class Act 1897, local authority shall means a municipal community, district board, board of commissioner or other authority legally entitled to or entrusted by the government within the control of the management of a municipal or a local fund. The term local authority includes local government and village panchayat. Local government includes municipal corporation, improvement trust, district boards, mining settlement authority and other local authorities for the purpose of the local self-government or a village administration. The village panchayat, it was held within the meaning of the term local authority. The village panchayat is also included in it. Let us know the case law of Mohammad Yasin versus Town Area Committee. In this, the Supreme Court held that the bylaws of a municipal community charging a prescribed fee on the wholesale dealer was an order by the state authority controverted in the Article 19A of G. Those bylaws in effect and in the substance have brought about the total stoppage of the wholesale dealer's business in a commercial sense. The next one is other authorities. It winds up the list of authorities falling within the definition of the state by referring to other authorities within the territory of India or under the control of the government of India. The functions and the government can be performed either the government departments and officials or through autonomous body which exists outside the departmental structure. Such autonomous body may include company or corporation. Now let us know the case study, that is Rajasthan Electricity Board versus Mohan Lal. Here the issue was that Rajasthan Electricity Board would come under the Article 12 state. The court applied the rule that if any authority is created by any law or constitution, it is very obvious that the authority will have a statutory power to affect fundamental rights of a citizen, and if any body has such power, that is necessary that such body shall be qualified to be a state, irrespective they are performing sovereign function. Hence here that Rajasthan Electricity Board was treated as a state. The next one is University of Madras versus Shantabai. The issue of this case is that the University of Madras, a state-funded university, fell within the definition of a state under the Article 12 of the Constitution. Hence, the High Court held, since the expression other authority is used after mentioning a few of them, namely the government and the Parliament of India, the government and the legislature of each state, and the local authorities, it would be reasonable to construct this expression with the government or a legislature. So, constructed it would only mean authority exercising government or a sovereign power and the functions. Is judiciary included in the word state? When the court performs their non-judicial functions, they fall within the definition of the state. When the courts perform their judicial functions, they would not fall within the scope of the state. In the case of Naresh versus State of Maharashtra, the court held it was even in the state, a writ under the Article 32 cannot be said to be violated under the fundamental rights. Thank you. Next video will be on Article 13, Pre-Constitution and Post-Constitution. Please like and subscribe.